On the phone, pleasure to welcome to the program Chris Paulos. He is an attorney with Levin Papantonio. Full disclosure, I work with one of those guys on Ring of Fire on the weekends. And Chris, thanks for joining us.
Glad to be here, Sam.
Now, what is it you guys got? You plaintiff attorneys? I mean, you're a trial lawyer, and one of the things I love about trial lawyers, in fact, the thing I love about trial lawyers, is that when you have a regulatory system that is so compromised by corporate influence, trial lawyers, plaintiffs' attorneys, end up being essentially the last firewall, as it were, to the practices of corporations to take advantage of consumers and workers. And I don't know a better instance of taking advantage of consumers than these stories about these different drug companies. Essentially, well, I don't know, how would you characterize this? Lying about their products?
Well, that's exactly it, Sam. The pharmaceutical industry and some pharmaceutical corporations have basically been blatantly lying to not only the FDA but consumers about the safety and the benefits of their drugs. And this has been going on for years. And there are certain regulations that allow trial attorneys and the Department of Justice to enforce the regulations set forth in our laws against these pharmaceutical companies when they commit these sort of egregious acts.
This is like whistleblower statutes, essentially.
Exactly. There's the Federal False Claims Act, and then a lot of states have enacted similar statutory schemes in their state statutes that allow either the Attorney General or the Department of Justice to bring a False Claims Act against pharmaceutical companies when they misbrand their drugs, when they promote drugs for uses that they are not indicated for by the FDA, or when they blatantly commit healthcare fraud by overcharging the federal government or the state government through their Medicaid and Medicare programs.
Let's talk about this GlaxoSmithKline. I guess it's a settlement. It is being hailed as the largest settlement in the history of, the largest settlement in the history of pharmaceutical malevolence. And we're talking about $3 billion in fines. We should start by noting that this is just a piddling amount relative to how much they made on this fraud.
Yeah, that's exactly it. That's one thing that's important to note when you look at this $3 billion settlement, and it is what the Department of Justice is calling it the largest fraud settlement in the United States history at this point, and it covers a period of almost 15 years, a litany, a literal laundry list of drugs that GlaxoSmithKline promoted for off-label uses and also ripped off the federal government. But they paid that $3 billion fine out of their cash reserves. It was a drop in the bucket for GSK, and it will be interesting to see if it has any punitive effect on the company. One thing that's
I can tell you right now. It's not going to have any more punitive effect on this company, which made $27.5 billion on the drugs in question here. $27.5 billion. It's not going to make any more punitive effect than the fact that I have to pay for broadband here in my office. It's just a cost. It's just a cost of doing business.
That's exactly it. They set aside money in their annual projections for these sort of settlements. And what's interesting to note is that GSK's stock rose when they made this settlement. So they actually benefited from settling these cases in their pocketbooks by getting a stock increase when they announced the settlement.
Unbelievable. All right. Well, so tell us what they did. What is this off-label? I mean, we hear this quite a bit. Tell us what this off-label marketing means.
Well, off-label marketing means that a pharmaceutical company has gone out and promoted a drug for uses that it is not approved for by the Food and Drug Administration. Basically, off-label uses are uses that maybe clinically relevant. Maybe a doctor sees that a particular drug is capable of addressing some issues or complaints from a patient, but that drug has not been studied nor approved for that use. Now, a doctor can prescribe drugs off-label as long as the doctor is fully aware of the risks and benefits of that drug and has a candid conversation and gets permission from their patient to do so. However, it is illegal for a pharmaceutical company to go out and market to a doctor and tell the doctor that they can write prescriptions for this particular use of the drug because the FDA has not given them permission to do so.
This is just sort of stunning. So, in other words, they'll take I guess in this case, it was like Paxil or Wellbutrin, and go ahead.
Yeah. The laundry list of drugs that are involved, the big ones that people are going to be familiar with are Wellbutrin, Paxil, and Avandia. Wellbutrin and Paxil were off-label marketed for use for use in pediatric indications. Excuse me, it was not indicated for pediatric use. So what basically happened here is that Paxil was promoted to doctors to use with children, when the FDA had specifically told GSK that it should not and could not be used with children. Wellbutrin was promoted for weight loss and ADD and quitting smoking and all of these indications that it was all of these uses that it was never indicated for by the FDA. And so another thing that's interesting is this settlement, although people are hearing Wellbutrin, Paxil, and Avandia, it covers a laundry list of other drugs, and that includes Advair, Zofran, Imetrix, Lotrinex, Flovent, and Valtrex. Basically, GSK was off-label promoting all of these drugs.
So this is, this was not like a fluke, obviously, right? I mean, they're actually going, sending white label, white paper reports, or maybe even glossy brochures saying you can use this for X, Y, and Z, and maybe not saying that, hey, incidentally, sometimes this is going to cause suicidal thoughts in kids or whatever it is. I mean, they're just, I don't, it's just sort of, how do they get away with this for so long?
Well, they have come up with a playbook, and almost every pharmaceutical company that I've litigated against, GSK, Merck, Bayer, just almost every single pharmaceutical company employs the same playbook. And what they do is first of all, what they do is they muddy up the waters of science. In Avandia, what GSK has settled here, is acknowledging here with this settlement, is that they withheld safety data from the FDA, and that data is important for the FDA to determine whether or not the product is safe and should be used as it's indicated. Well, they withheld that, and every company that I've dealt with has done that. And what they do is they basically cook the books. They are told that they need to conduct studies, and then when the data in those studies isn't going their way, when it looks like their drug might be more dangerous than what they've already told the FDA, they basically will massage the data or cherry pick the data or manipulate it and then turn it over to the FDA in a favorable light. And internal documents from these companies will always show this sort of behavior.
That's what we saw with this whole Pfizer story, right? I mean, in this case, we're talking Celebrex.
Yep.
They were sort of massaging. I mean, does Celebrex even have any value? I mean, aside from obviously the billions of dollars in sales to Pfizer, but I mean, it seems like it's basically ibuprofen, but maybe more dangerous.
Exactly, and what's frightening, Sam, is that we really won't know if Celebrex has any benefit until 2014. That's what's so egregious about Pfizer's behavior with Celebrex is that they literally play by play followed that playbook. They cherry picked data. They massaged their clinical trial data. They submitted partial data to the FDA to get the information they wanted. Meanwhile, they're making $2.5 billion in sales, and then they get caught. Manipulating data and basically appease the FDA by saying, okay, we'll release all of the data that shows our drug is safe in 2014, which just happens to be the same year that their patent on that drug expires.
I'm sorry. I don't mean to laugh about this. This is just stunning. I mean, you read some of the emails. I mean, I guess this came out in this story's from the New York Times from a week or two ago. And you read the research chief's email sent in 2000 talking about a study they showed claiming that the Celebrex was safer on the stomach than more established drugs. He wrote, "They swallowed our story, hook, line, and sinker." I mean, I don't understand how these people. I mean, how do you live with this? I don't understand. When you get these guys up on the stand, if they end up going that far, what do they say?
Well, it's the common approach of denial, or it's taken out of context. What's interesting in the Celebrex story that you talk about in the New York Times, they even put out their public statements are, oh, well, these documents are taken out of context, or we don't recall ever writing those documents, or I don't know exactly what I meant when I had typed that in an email. It's just they kind of dodged the question, and at a trial, we love to play that in front of the jury, but at the same time, they're taking no responsibility. And what's interesting about that article that Katie Thomas from the New York Times wrote on June 27th, and the thing to me that's the most frightening about that entire article is that, and I quote, Katie Thomas says here, "Company officials have said that the drug has demonstrated its worth and safety, and it has done so. The proof, they say, of its worth and safety is that 33 million Americans have taken it." Now, that statement basically goes to show that the pharmaceutical industry treats us as guinea pigs. I would certainly like to know that all the drugs that I take have gone through rigorous testing, that all of the data has been provided to the FDA, and I'm using it for an indicated use. And that one statement alone basically destroys that whole myth.
Is the problem here that we do not have complete enough regulations? Or, I mean, in other words, would more regulations help, or is it simply that these drug companies are not following the law? They're breaking the law, and when they get caught, they have a fund set aside to pay their bandwidth or whatever it is, this cost of doing business. Is the problem a weakness in the laws, or a weakness in enforcement, or both?
I don't think it's a weakness in the laws. There's always a fine line that you have when you're creating a regulatory scheme. People need access to healthcare. People need access to drugs. And you don't want people to be stifled from accessing safe and effective drugs for things that they need treated. But we certainly do have an enforcement problem. We've got an incestuous, for lack of a better term, relationship between the FDA and pharmaceutical companies. They're always constantly jumping the fence. Folks who sit on the FDA advisory committees that look at the safety of these drugs are often employed or have conflicts of interest with certain pharmaceutical companies. And then also the ability of the Department of Justice and the OIG to enforce these regulations is often stifled by budget concerns and manpower. The FDA doesn't have an enforcement arm. They do not have a police department that runs around the country slapping folks in handcuffs for violating their regulations. And we do have regulations or laws like the Key Tam and False Claims Acts that allow us to enforce these sort of regulations. But the resources the Department of Justice has are spread very thin.
Yeah, in fact, the Glaxo thing, if I understand it, was a function of Eliot Spitzer as Attorney General of New York when he was digging into this stuff. Is that right?
Yeah, it's actually interesting to see that this GlaxoSmithKline, this most recent settlement, was a combination of state attorney generals and U.S. attorneys from a wide array of states from across the country, as well as a cooperation amongst the FBI, the FDA, Health and Human Services, the Office of Inspector General, and the Department of Justice. So it's this, and what's interesting is Attorney General Eric Holder and Kathleen Sebelius announced what they call the HEAT program, and this is the program that they put into effect in 2009 that allows the the federal government to go after healthcare fraud and use the False Claims Act and the Food and Drug and Cosmetic Act to enforce these regulations, or at least stifle these instances of fraud by these corporations. And so it's a good example of that. But what's frightening is that the ability of the Department of Justice and attorney generals and U.S. attorneys to use these regulations to enforce these laws is also being attacked by tort reformers and our good buddies at ALEC and the Chamber of Commerce and the American Tort Reform Association. They are now going around the country and trying to enact model legislation such as transparency in private attorney contracting. It's called TIPAC, or PARSA, which is the Private Attorney Retention Sunshine Act. Because what happens is a lot of times these attorney generals and U.S. attorneys employ private attorneys such as myself to help them litigate these cases. And now ALEC is trying to prevent that from happening. So you'll have an attorney general's office that has got no budget to enforce these cases, but has a duty to the consumers in their jurisdiction to protect them from these sort of predatory business practices. And then now they can't even bring in a private attorney to help them, assist them to enforce these laws.
And when an attorney general brings in a private attorney like yourself, is it all based on essentially on what are you paid up front, or is it paid as a function of the settlement? Or
it's paid under depending on the agreements that are drafted. And these agreements are open to the public, and under state statutory schemes, attorney generals have to reveal these sort of agreements. It just depends on the nature of the litigation. Most likely, in a qui tam setting, it is a contingency fee, but it is the relator, the private citizen, who basically rings the bells, the whistleblower, who gets a percentage of the recovery, and then attorneys' fees for private attorneys comes from a percentage of that percentage itself.
And is there ever an instance where any of these people go to jail? Because it seems to me like we're seeing also with what we see with the SEC and when the banksters commit this type of fraud and whatnot, that unless people start actually going to jail, nothing's going to change, because this just becomes a small margin, a small cost of doing business. Fine, we make $28 billion, we pay out $3 billion. That's not a bad ratio. Are there instances where people go to jail? I mean, what exactly do you have to do if you are the CEO of a Glaxo or a Pfizer? What do you exactly have to do to go to jail when you're talking about basically promoting the use of your drugs, which could lead to people's deaths, will lead to, obviously, to higher medical costs across the country, et cetera, et cetera? What do you have to do?
Aside from committing blatant homicide, I don't have an answer for that, because these folks aren't going to jail, and their behavior is so egregious, and it gets worse every time. Every time you see one of these settlements, the documents that are actually revealed, the behavior, the knowledge on behalf of the folks who are working for these companies, you think these folks would go to jail. At least one person would go to jail, but I know of no instance where someone has. And that is exactly why we have such a horrible culture of recidivism of this type of behavior in the pharmaceutical industry.
Yeah, I don't even know if you can call it recidivism, because it's basically just like, this is just, we plan for this. This is the cost of doing business. I get shocked by this stuff. I know you must see it on a daily basis, but it doesn't stop. It never ceases to amaze me. And I just don't understand the people who work at these companies who are willing to do this type of stuff. And I got to say that if I ever leave this show, folks should be looking for me at law school. I'll go back. I'll get my degree. This is if I had known about what you guys did 20 years ago, I probably would have never done any of this.
Yeah, well, it certainly keeps you up at night, but it also helps you get up in the morning to go out and fight the good fight when you have folks out there committing crimes, literal crimes, and hurting people at the price of a few dollars per pill in their pocket.
Chris Paulos, plaintiff litigator, plaintiff lawyer with Levin Papantonio. Thanks so much for joining us.